Hi, my name is Raj Sharma. I'm the managing partner at Stewart Sharma Harshani, one of Western Canada's largest dedicated immigration law firms. Today I'd like to talk about removal order appeals, specifically those that involve criminality. If you're a permanent resident of Canada and you've been convicted of an indictable offense here that is subject to 10 years or more possible sentence, or you've been sentenced to less than 6 months, you retain an appeal against the removal order to the Immigration Appeal Division. You do not have an appeal to the Immigration Appeal Division if you've been sentenced to a term of imprisonment more than 6 months. A permanent resident of Canada can be found inadmissible, can face removal from Canada even if they've committed an offense or been convicted of an offense outside Canada. This offense outside Canada must be equivalent to an offense in Canada with a maximum sentence of 10 years. If immigration is calling you in to discuss your potential inadmissibility to Canada, it goes without saying that you should probably contact experienced immigration counsel. My first tip is this. If you've been sentenced to more than 6 months imprisonment in Canada, you don't have an appeal to the IAD. But don't think that this is the end of the road. Don't think that deportation is a foregone conclusion. Don't think that deportation is automatic. An officer retains the discretion not to write the report or not to refer the report. I've seen individuals that have had sentences of years in jail and that the officer has decided not to write a report and not to refer it. Remember, a report is what initiates removal order proceedings. And so it's imperative that if you are sentenced to more than 6 months, that you don't think that deportation is going to be automatic. You should try to convince the officer to exercise his or her discretion not to write that report. Tip number 2, if immigration thinks that you've committed an offense or you've been convicted of an offense outside Canada that's equivalent to an offense inside Canada, you need to talk to experienced immigration counsel immediately. This gets really technical. And it's quite difficult. In this case, depending on the offense that is alleged, there may not be an appeal to the IAD either, and you may face yourself removal to a country against which you may not have the rights that you have in Canada. Tip number 3, if you're heading to the Immigration Appeal Division, now remember, this means that a report has been issued against you. It means that you've been sentenced to less than 6 months. It means that the Immigration Division has found the report to be well-founded, and you filed an appeal to the Immigration Appeal Division within 30 days of receiving the removal order. If you're heading to the Immigration Appeal Division, you've got to understand you bear the onus. You have to establish that there's sufficient humanitarian and compassionate considerations. These are called the Ribic and Chew factors. And these factors should overcome the removal order. But it's up to you, and you have to prove it, and you've got to present your evidence. The Ribic and Chew factors, the evidence that you need to establish, these typically go towards your establishment in Canada, your family in Canada, your community support in Canada, the hardship that you may face if you're removed from Canada, the best interests of any children affected by the decision. But again, don't think that you'll be able to appeal the Immigration Appeal Division or negative finding further. The only thing that you've got after the IAD is a judicial review application to the federal court, and the federal court does not lightly intervene on findings by the IAD. This is your one shot, so make sure you take full advantage and present the best case possible. My last tip, I've done a lot of criminal removal order appeals. In my opinion, the IAD is only going to grant relief if they think that you've demonstrated sufficient remorse and insight as to why you did what you did. And there's got to be some evidence of rehabilitation, something for the IAD to be satisfied that you're not going to do whatever it is that you did again. That's very, very important in criminal order appeals. Remorse, rehabilitation, insight. Those are my tips for criminal removal order appeals. If you have any questions regarding appeals to the IAD or any other immigration issues, please do not hesitate to contact any of the lawyers at Stewart Sharma Harshani.